South Asian constitutions speak of constitutional machinery failure, a colonial-inspired term. And this, the provisions of these constitutions allow the central or state government to suspend the operations of states within the Union. This is, of course, a deeply contentious tool and a political tinderbox. On the other hand, when confronted with some national emergencies, for example, wide-scale political violence, a 9/11 style attack, or a climate disaster, a high degree of coordination may be needed on an urgent basis. In this respect, the Emergencies Act is a relatively weak and deferential instrument. It acknowledges the possibility of a national emergency without providing the means to coordinate effectively across multiple levels of government. It does require consultation, but consultation is not coordination. Of course, any centralized response must also be subject to effective accountability mechanisms, which we'll come to later in the session. But a genuine national emergency will require an effective, coordinated response, as well as an effective and appropriate accountability mechanism. I'll have more to say on this point later, but let me stop here for now and yield the floor to my colleagues.
Thank you very much. Hoy?
Thank you so much. Professor Lazar, when Professor Lazar introduced the panel today, she mentioned that it's really difficult to get text right around the emergencies. There's a certain measure of necessary ambiguity. So what I would like to present on is, to think about, is how to avoid controversy that's unnecessary. Yeah? How can we draft the text to avoid interpretations that either give rise to controversy and contradiction, and avoid and ensure that the text is tied to the specifics of the emergency context. So let me start with this question of unnecessary contradiction. So the closing phrase of Section 3, the definitional clause, states that a national emergency is one that cannot be effectively dealt with under any other law of Canada. Now, on its face, you might think, okay, so if we had a province and the province could effectively act under its laws, but decided not to, we wouldn't have an emergency, right? I mean, that's just sort of a plain reading of the laws of Canada, the law of Canada. Provincial laws are laws of Canada. But if you look at Section 3A, right, Section 3A says that you only have a national emergency if you have a situation that is of such proportions or nature as to exceed the capacity or authority of a province to deal with it. Right? So that clause, Section 3A, rules out the interpretation that you could have a province who had the capacity under its laws, but simply decided not to use it. That's an example of avoidable controversy. Now, going forward, I would suggest that if the Act is amended, the Parliament avoid using terms of art such as law of Canada. So, and I'm indebted to this for this point to Professor Leah West, right, who notes that law of Canada in a case, 1989 case, Supreme Court case of Robert against Canada, defined law of Canada and limited it to the laws of Parliament. But as I say, I think it's unwise to use terms of art that give rise to contradictions in interpretation just on a plain reading of the text. Second, on the question of ensuring that language is tied to the specific context of emergencies. Excuse me. So Section 16 of the Emergencies Act, in its definitions of public order emergencies, refers to Section 2 of the Canadian Security Intelligence Service Act, right? It's an incorporation by reference. And so what is understood to be a threat to security of Canada for the purposes of the Emergencies Act derives its definition from another statute. Now, incorporation by reference is, of course, a common drafting technique. But I think it gives rise to potential problems in this context. As Professor Lazar noted, emergencies are specific. They are exceptional. So if you use the language from another statutory regime, it is reasonable to think that the language should take its meaning from that context. Yeah. Now, if the courts were to review executive action, as Professor Lazar noted, they will typically defer to the interpretations of the executive. But I think we can avoid this necessity of recourse to the deference of the judiciary in the interpretation of the statute, and rather house all of the terms within the Emergencies Act to ensure that all language is relevant and specific to the context of emergencies, and again, to avoid unnecessary controversy. So as I say, Emergencies Act.
Thanks. So this actually, I think, follows quite well. There's been lots of discussion about whether the government's declaration of an emergency met the threshold of threats to the security of Canada, and I don't intend to go over that ground. It's been plowed quite a lot. I did, however, want to say a word about the other part of the threshold that has to be met, and that is the public order, that the public order emergency is so serious as to be a national emergency, and in particular, I wanted to focus on the requirement that the matter can't be dealt with effectively under any other law of Canada. And like Hoy, I am indebted to Leah West also for her explanation of the term laws of Canada, and I agree with her interpretation that refers to federal statute law or federal common law. So how is this requirement to be interpreted? And I can think of three possible scenarios. First one, most clearly, is that there may in fact be no other law of Canada that even, comes close to addressing the emergency situation. Alternatively, it may be that there are laws that exist, but there are reasons for not resorting to them. For example, there may be laws in place, but there are operational barriers to the effective deployment of the law. For example, if there is inadequate enforcement capacity, or if there are procedural requirements which couldn't be fulfilled in a timely way. It may also be that there are laws in place that may, in the view of the government, be more harmful to individual rights or to social cohesion than the invocation of a temporary emergency. And in the questions we got, the example that was given was the possibility of resorting to the National Defense Act use of the civil power. And the government did not do that. In fact, I think there was some testimony, maybe from the National Security Advisor, who said something to the effect of, doing that would just inflame the situation. So with respect to that example, there's a question as to whether the concept of effectiveness captures this reason for not resorting to bringing in the military. Maybe some consideration should be given to a different or additional criterion to be added to Section 3 that might take into account the government's judgment on the appropriateness of using a law that it deems excessive in the circumstances. You start to get into proportionality and minimal impairment analysis. And one of the things that was distributed to us was a paper that Professor Lazar did for the commission, setting out some examples of what the government should consider to meet the reasonable belief that the emergency measures are necessary. And I'll mention two that are relevant to this discussion. The first is that the measure taken had the practical or technical capacity to bring about the outcome. And the other is that the government will not just aim to resolve the situation, but to do so in a normatively appropriate way. So the government might wish to resolve the situation, and here I'm using Professor Lazar's words, either quickly or safely or fairly or cautiously or efficiently or decisively or expeditiously or cost effectively. But I think the same criteria could be applied to determine whether other laws of Canada are not effective or appropriate. They may be available, but would either not have the technical or practical capacity to bring about the outcome, or they could not do it quickly, safely, fairly, etc. The government's required to believe on reasonable grounds that a public order emergency exists and necessitates the taking of special temporary measures for dealing with it. That judgment is subject to judicial review by the courts and subject to review by Parliament and by the inquiry that's established after the emergency is over. All three of those accountability mechanisms should require the government to clearly explain whether there were other laws that on their face could have been used and why they were rejected. And the first opportunity to provide reasons for why other laws of Canada would not have been effective is the explanation. In the explanation,
Charter regulated by statute that is completely under the jurisdiction of the Charter. So in some sense, no derogations are permitted. But what's striking to me about the Emergencies Act is that in the course of deciding whether to trigger an emergency, all that is there as part of the threshold is an assessment of the danger involved and not an assessment of the rights that might be infringed by declaring an emergency. The fact that the Emergencies Act will ultimately be assessed under the Charter by the courts or otherwise suggests that perhaps proportionality analysis and thinking about the impact on rights should be built back into the Charter as an exercise that the executive should go through before actually deciding whether or not to trigger an emergency. Because of course, in the end, the Charter will apply, but the Charter does not require overtly on its face that the executive actually engage in proportionality analysis. What I assume is that because the Emergencies Act was enacted around the same time as the Charter, it was enacted before the Supreme Court of Canada developed the robust proportionality jurisprudence that it has now. And so it looks to me like the Emergencies Act is kind of a victim of the year in which it was written, which is really before the Supreme Court of Canada had developed such a robust system for assessing impacts to rights. So if one of the purposes of the Commission is to think about how the Emergencies Act might be improved, I would suggest two things. One is to think about what I call this pre-emergency stage to ensure that charter rights can be realized while at the same time tamping down the possibility that an emergency would have to be declared. And second of all, requiring that to trigger an emergency, the executive not only do, but also make public a proportionality analysis that shows that the executive has taken into account the impact of any emergency declaration on rights. And with that, I'll hand back to the committee and thank you very much for the opportunity to discuss this with you.
Thank you, Kim. Karine?
Hi, thank you. Do you hear me?
Yes.
Thanks so much. So I'm Corinne Levy. I'm talking to you from New York. I manage the doctoral program at the law school at NYU, and I do my research with the Institute of International Law and Justice. And I think I'll kind of follow Kim on some of her points, especially my take will try to take us away from this notion in which we started this roundtable today of a necessary, controversial, necessarily exceptional situation that we deal with in emergencies. So, and I'm going to take a broad perspective because I'm not a Canadian. Again, I'm going to talk from a theoretical perspective and from a general perspective. So what I want to do in my comments on the issue of threshold is to shed some light on the problem of thresholds in emergency powers more generally, which is the problem of defining the concept of an emergency and defining and identifying a particular situation as an emergency. And my claim is that the language that the Emergencies Act uses to mark the threshold for an emergency declaration is misleading and unhelpful. It orients the focus of the decision maker and the public to the unknown, the unmanageable, the borderline condition of incapacity, instead of what we really need in times of crisis, which is to focus on capacity, on the many different resources that a society has to confront threats, especially Canadian society. So the threshold of emergency has always been a point of anxiety for theorists of emergency powers and for practitioners of emergencies. This is because emergency is commonly understood in the literature as that which defies definition. Emergencies are defined by their exceptionality, by the fact that they raise occasions for the use of special exceptional power. Think about Carl Schmitt's famous or infamous definition of emergency as a threshold concept, a borderline concept. Emergencies for him is that which is not codified in the existing order, a situation that cannot be circumscribed factually, a case in which the preconditions and the content of jurisdictional competence are necessarily unlimited. So ultimately, we know a real emergency is one which the sovereign decides it is, because the sovereign can act against the law to declare the threat and how it should be solved. And this, unfortunately, is the way that many debates in our area express the problem of threshold. Even theorists who are less skeptical than Schmitt about liberal law and about liberal political institutions are influenced by this anxiety. And emergencies, again and again, are defined as extreme liminal events, so that a threshold is placed at the very limit of capacity, signifying the very limit of law, yet contained by law. The problem with this framing is that it encourages a politics of emergency governance that is focused on incapacity and liminality, and that overshadows the real important questions of capacity that defining and identifying emergencies raise. Not only questions of what is the threat, but about who is capable of identifying threats, who holds the knowledge, on the basis of what evidence, what are the processes, methods, standards for identification, what are the levels of consultation, levels of cooperation between agencies and across jurisdictions for determining threats and capacities, etc. Such questions that have been raised before the Commission in the last few weeks are sidelined when the emergency is assumed to be completely exceptional in this liminal way. And although Canada's 1985 Emergencies Act does not correspond to a Schmittian theory of emergencies, in fact, it clearly rejects it. Its language reproduces the anxiety of threshold in this way. So what is the emergency that the Act envisions? And we heard it before, so sorry, I'll try to be brief. And again, we're talking about national emergency as defined in Section 3, and which applies to all the different types of emergencies that can be declared according to the Act. So it is an urgent, critical situation, temporary in nature, that seriously endangers lives, health, or safety of Canadians, and exceeds the capacity or authority of a province to deal with it, or threatens the ability of government of Canada to preserve sovereignty, security, and territorial integrity of Canada, and that it cannot be effectively dealt with under any law of Canada. Now, this language, as others said before, envisions what I call a triple incapacity threshold: incapacity on a provincial level, or incapacity on a federal level, and legal incapacity. By that, it seems to create a very high threshold for the declaration of emergencies, right? But a close reading of it shows that it replicates a Schmittian anxiety about the liminal case. It is oriented to the very extreme case in which competence is lost. And as soon as we accept that we pass this threshold at the very moment of this extreme incapacity, it births or imagines an all-powerful executive who can really take charge. This is an absurd framing. It is responsible for the endless arguments that I think the Commissioner heard in the evidence before him about whether there was really no other law or there was really no other capacity anywhere to be found. Of course, there is law. Of course, there is capacity. It is the law and the capacity that we should be interested in if we want to serve the real purpose of emergency government, which should be, as we heard yesterday in the panel jurisdiction, to avoid the exceptional, extraordinary power to carefully construct and reconstruct regularized coordinated, multifaceted, multi-jurisdictional capabilities. So this is my note on the threshold. Thank you.
Thank you, Karine. Ward?
Mr. Commissioner, I'm not, well, I'm a lawyer, or was a lawyer by
Folks, if you want to be kept up to date on what's happening at the Emergency Act Inquiry, including my live tweets and some clips and highlights that occurring at the Emergency Act Inquiry, by heading over to revolutionnews.ca/Emergency Act Commission. That's revolutionnews.ca/Emergency Act Commission. And of course, here, folks, while you're there, please head over to donorbox.org/Emergency Act Commission. That's donorbox.org/Emergency Act Commission. And of course, here, folks, if you could chip in a buck or two, that will be greatly appreciated, as it will help me cover my travel expenses, including my expenses on food, as bringing you these stories doesn't come for free. Thank you so much.